is, well, behind, right? But now there's an item on how far is the law behind. So Dai, may I give the floor to you?
Thank you.
Thank you very much. Oh.
It's all right, I wouldn't clap beforehand, you haven't heard it yet. I'm going to bore you with 2 minutes of non-law stuff. So, why is artificial intelligence so in the news at the moment? It's in the news because, of course, ChatGPT launched just under 2 years ago. ChatGPT is what most people are familiar with when it comes to artificial intelligence. At the moment, by which I mean ChatGPT, but anything else you want to, any other bit of research you want to look into as well, which hasn't yet reached the public, it's neither artificial nor it's intelligent. It's not artificial because it's very clever, it is very clever, statistics, and that's all it is. You ask it to write something about Queen Elizabeth, it's Queen Elizabeth I, it's read 750 million books, 750 million books, a lot more than you and I could read in a lifetime. So when you ask it to write something about Queen Elizabeth I on a one-page summary, it can do it far better than any history professor who specialises in that area, because it can read the 750,000 books, actually 750 million books, and produce, using statistics of all the books it's read, a very good one-page summary. I asked Juliet before this started to give me a noun. And the noun she gave me was pink balloon. So if I asked you to write a one-page summary on Elizabeth I and put the word pink balloon in it, you'd struggle. You couldn't do that as well as ChatGPT do. Trust me, do it afterwards. You'll find that ChatGPT can do a brilliant summary of Queen Elizabeth I, put the words pink balloon in, and you think, how on earth did it do that? Much cleverer than you and I could, because it'll look at all the references to pink balloon in the 750 million books and use one of the best ones and put it in the middle. So with that very, very concise summary of AI and what AI can do very well, very well, what can't it do? Well, it can't do what we're doing now. It can't speculate and it can't talk about things that it hasn't read about. If you ask it, if that's why it hallucinates. That's why it gets stuff wrong. It gets stuff wrong because if it looks, for example, if I asked you, one of the sessions we could have had here would be, I don't know, a comparative law session on the joint ownership of copyright. All right? And every country has slightly different rules when it comes to joint ownership of copyright. What AI can't do is distinguish between country A, what the rules are in country A, and what the rules are in country B. So when you ask it to do something from a legal perspective, it's looking at all those things and it's trying to produce something which might be nonsense. And it might be nonsense because it's looking, in that particular case, at lots of things with different contradictory sources, contradictory answers, because they're different answers to joint copyright ownership in different countries. Similarly, if you ask it a question where people haven't written the answer, it has no idea, and that's why it hallucinates and gets stuff wrong. So, easy to distinguish between what it does very well, which is stuff that's being written down already, and stuff that it does very badly. It has no idea what a Queen Elizabeth I is. It has no idea what a pink balloon is. It's just statistics. So, with that very short background, I'm going to introduce Ismo and Alesch, who are going to take the first 35 minutes of this session to talk about generically the law of AI, the copyright and other attributes, negligence, and how it applies to artificial intelligence. Alesch and Ismo I've known since the Helsinki conference. Alesch is based in Zurich at the Swiss law firm Uto Legal. He is a mediator. He's spoken at conferences before, and he's also experienced in-house because he used to be IBM's European lead counsel for their research division. Ismo is a partner in my very old law firm, which is Evershed, and he has experience in both civil and criminal litigation. Ismo is highly qualified to do this talk and to participate in this session because Ismo has actually written a book entitled The Law of Artificial Intelligence, Proprietary Rights and the Issue of Risk Management. So without further ado, I will leave to Alesch and Ismo to explain their ideas.
Hello, everybody. Can you hear me? Yes, I guess so. Sorry?
There is a mic now.
But I think I have one, so it should work. Can you hear me? Good. So one question to the audience, and it may seem out of context, but it is not. Do you know what a dog is? Good. Who said that? Okay. Do you have a dog?
I don't.
Okay. Who has a dog? Okay. What is your name? Are you based in Holland?
Yeah.
Okay. And you know what a dog is?
Yeah.
And you have one. So you frequently interact with your dog? Okay. Great. So are your interactions with your dog and your dog's interaction with environment, are they regulated?
Somewhat, yes.
Okay. And so regulated by the Dutch regulator?
Yes, you can't go anywhere.
Okay. Good. Good. And so do you believe your regulator knows what the dog is as well?
Yes.
Okay. Is that a good thing? Bang. So, okay. Because I think we have a situation where we are trying to regulate something where we don't know what it is. And actually the European regulator has proven that. So let me jump to that. Here it is. And that's the only slide where I have to constantly look it up and compare it because it's so complex. So do I have a pointer? Probably not. No. Anyway, so in April 2021, the EU regulator came up with the first draft of the EU AI Act and provided a definition of what AI systems are. That's actually the original definition on top. And I will make a line-by-line or word-by-word comparison of what the definition is now. Because what has happened? A year later, ChatGPT came up. At that time, they still had the original definition. And since then, many things happened. And generative AI popped up everywhere. It's the big hype these days. And so they changed quite a lot. So they started to wait. We forgot about copyright and patents. We need some IP provisions. They added IP provisions, just some. And maybe we should redefine the subject matter of the AI Act. So I think if you define, imagine the smart Dutch regulator has a law, a code on how to deal with dogs. And a year later, wait, we have a misunderstanding what a dog is. So let's redefine the subject matter of the act. So I'm not sure whether this is a good way, but that's what happened. So if you look, originally they referred to software. Now they're referring to machine-based system. Originally they said it's developed with one or more of the techniques and approaches listed somewhere, hidden in the act. And actually that has totally vanished. Because what happened when it was published in April 21, many IT experts said, first of all, you claim to come up with a technology-neutral act, and you list quite many information technology technologies, and I would say about 60 or 70% of these technologies were considered to be outdated at the time of the publication of the first draft. So that has vanished altogether.
Yeah, and as we talked with Dr. Alesch, the original definition, it was insane. There were criteria which, if were fulfilled, the system was considered as an artificial intelligence. And to give you an example how it was defined in that appendix that Alesch is referring to, one criteria was that if it uses certain mathematical theories related to probabilities known as bias estimation. I don't know how many of you have a background in computer science like me and who have done this applied mathematics, but this bias estimation, it originates from year 1736 or something like that. So basically EU was trying to make law where 300-year-old technology would qualify something as artificial intelligence. That's why it was considered insane. And then, therefore, when we consider these AI-related issues, they change, as Alesch said. And therefore, not only the question of what AI is, an equally or even more important question is what AI is not. And that is what Dai said in the beginning. It's important to understand what these systems are not. If we consider these large language models like ChatGPT or the like, they are not intelligent or something like that. They are more, they are computer programs which are extremely able to do probability calculations. ChatGPT, in essence, is nothing more than a probability calculator. But go on, Alesch.
Yes, so I totally agree. It's very important also to understand what it is not. And, depending on our perspectives, it may differ quite a lot. So if you look what has been added these days, so, since the original referring was to software, now it's broader, it's machine-based systems. Software is typically developed, so it's referring to develop. Now it's designed, slightly more modern, maybe also more in line with GDPR lingo, privacy by design and all that. And what is very interesting now, it says it's operating with varying levels of autonomy. So that's new. And that may exhibit adaptiveness after deployment. And that's, to me, a euphemism to say, well, once the robots are out there, they will do whatever they want, so they're out of control. I think it's just a very euphemistic way to phrase that. It says for explicit or implicit objectives, before it said for a given set of human-defined objectives, so it's now more independent, so to say. The only thing that is actually the same is generate outputs, such as predictions, content, recommendations, or decisions. And more or less that they can influence physical or virtual environments. So for better or for worse, that is the current definition of what an AI system is. To me, I think sounds good. I like the more technology-neutral approach. I think it's a work in progress. It will change over time. And over time may mean maybe within the next 6 months, we don't know, so development is very fast. The original question raised by Dai is how far is the law behind? Extremely far, but I think that's just a natural thing with law. Law is always behind technological advances, society advances, changes in society. So I think that's a given that has been, in Stone Age, they probably regulated the use of fire somehow, and the law were behind. Yes, of course.
No tension in store. And much talk. I brought the feet cautious for the edit, you don't right, because otherwise I don't really have fun one. But thank you for the question, but I'm getting the question on further. Where is anymore?
Okay. So sorry, but good. Yeah. So we don't really have a presentation. So we have talking points, and we want to, my colleague is from Finland, I'm from Switzerland. I believe our legal systems are quite similar. Those continental European systems as opposed to the common law approach. And, I think we have to tackle all these things on an international level. And so let's start with the discussion on these items. And we will be just,
If we consider the basic situation, we have existing laws. The courts, when they are facing a matter, whether it's about dogs or whether it's about AI or sale of goods, the courts, they cannot reach a non-liquid decision. They must decide the matter. They can't say that there's no specific legislation regarding AI. Instead, they must decide. They are obliged to decide. And therefore, how we are operating now is that we have the existing laws. Now, as a new material thing, substantial thing is AI, which creates a new phenomenon that courts must decide upon and use laws that exist. Should I briefly go through this? If we consider about the development of AI systems, those of you who have been involved in software development, either as lawyers or maybe some of you have also technical background, everything begins with the requirement specification, what the system must do. Is it ChatGPT, which creates text? Is it Midjourney, which creates images, and so on? Then, when you have defined what it does, you create a structure, how these are implemented, and then you implement that. Basically, it means that you write the code. And I think that Alesch and I, we fully agree that there we have a protection of trade secrets related to these structural things, requirement specifications, structural design, and so on. And then we have copyright protection for the actual code that is written.
Exactly. I mean, it all comes to writing code. Whether you ultimately call that software or a machine system, I think, or a machine-based system, I think doesn't matter a lot.
Yeah, and one thing that I have noticed within development of these AI systems, and because of my background, I've seen it in a very detailed level. These requirement specification and structural design, they are typically protected as trade secrets. And that raises the question, because really trade secret protection for development of AI systems, it's important. And the reason for that is, in mathematical sense, the algorithms that are used to create these AI systems, like the Bayes estimation, 300-year-old mathematics that I said, or neural networks. Neural networks, they are nothing new. In mathematical sense, the theory of neural networks, it was created in the year 1942, during World War II. It's that old. Then deep learning is a little bit newer. But regarding design of AI systems, the important thing is to invent novel ways to utilize existing mathematics. Yep, and then we have training material, which is, of course, it can be anything. It can be books, like Dai said. It can be images, like it has been, but let's say that you do some traffic control thing. You would use data from road surveys and so on, how people drive and so on, and design an AI that might control public traffic and so on. And of course, as Anna and also already spoke about, data will be important, because data as a training material, it's the oil for artificial intelligence. You have to have something to train them.
Yeah, if we try to summarize here, I would say we basically have two things. So we have the protection of the AI system as such, and that's the specifications, that's the structural design, that we didn't all that. So that could be copyright. If you have written code in particular, if there is something evolving from pure algorithms, from pure guidelines, directions. So once there is basically the expression of the original idea, then in most laws we can afford copyright protection. And of course, as you mentioned, trade secrets, very often bilateral protection. Basically, you just have to keep it secret and maybe place your contractual measures, such as NDAs with liquidated damages and contractual penalties and all that. But I think that's all quite straightforward. And that now it gets interesting because now maybe let's talk about
the protection of output.
Yeah, exactly. Yeah, and maybe a brief word on training materials. Of course, these can be copyrighted. Obviously, I mean, it's newspaper articles, and we've had cases in the US where actually word by word versions of articles came out, and so I think that's the really interesting thing when there is strong evidence that the training materials were copyrighted.
Yeah, and then if you consider the outputs that these AI systems create, by coincidence, there are scientific articles that Alex has published and I have published. And we have reached the same conclusion regarding images, text, and so on independently. We're not aware of each other's articles in that sense. And we kind of like share an opinion that if you write a book with AI, and of course you can use any other style, you can say that write the text like Hemingway, write tricks like Proust, which would be the other extreme. And you can teach it any style, it's easy. But when it writes the book, whether the book is actually copyrighted or whether images that it creates are actually copyrighted, go on with these images. You wrote nicely about that. You had a good, your example about the UK threshold for protection. That, yeah.
So,
because I agree with you.
I must say, I think here things gets tricky, and I think they get trickier. I mean, overall, one can say as long as the machine has been, the original issue with copyright protection is almost all laws require a certain human interaction, a human factor in copyrightability. So you just can't just say, oh, it's the machine and I physically own the machine, I commercially own the machine. That's not sufficient. So you have to show that basically there is individuality linked to a human person. Some other laws would refer to originality, but it's more or less the author's personality that must be reflected in the work. And if there is too much abstraction in the creation of the work, so if you can't find that human factor, it's going to be tricky. Now the question is, if you have a machine and the machine generates output, you could still say, well, wait, the input, basically the prompting was very original, very copyrightable. Now, here it gets tricky. Some laws explicitly say, for instance, in the UK, the person, I don't, if there's someone from the UK, you know it much better than I do. You're from Canada, but that's something different. You're from Canada. So I think more or less the UK Copyright Act suggests, well, Dai, you are the UK, suggests that the person that is attributable to having given the decisive arrangements to the machine or to the instrument is regarded as the author. And I think that makes sense. And ultimately, even on the Swiss law, or on the Finnish law, if I tell, a machine or another person exactly what to do, then even though that person mechanically did what I said, I'm still the author.
Yeah, and if you consider this issue about machine creating art, so for some reason, with AI, there's a strong opinion that the AI can't create art because it's machine. But I think that in most countries, photography is one form of art protected by copyright legislation, either as such or with some kind of neighboring right. And if you can make art with camera, which is a machine, it would be illogical to think that you can't make art protected by copyright with AI. It's just how you use it, and unfortunately we can't show you it. But Alex and me went through certain material in professional use. For example, in construction and architecture and fashion, AI is used more and more and more. You saw these construction materials and so on. There is used the prototype. It's much easier to prototype a house than draw it by hand. Actually, you can buy separate books of how to use AI for architectural prototyping or fashion photography, and so, those. But go on.
Yeah. So coming back to the prompting, and you made the example of writing something in a Hemingway style. I mean, just copying someone's style is not a copyright infringement, so that's possible. Let's maybe transpose it to music. If I try to compose a song, I say, well, it should include some shouting in the style of James Brown. It should have a chord, like a 2-5-1 chord progression. It should be in B minor. It should have a funky groove. All that is more style. So it probably could be difficult to argue that the output then is linked to my personality, and that's why I could ask for copyright protection. And why I'm saying I think it's going to be tricky, because on the long run, a lot of creation of things, like be it music, be it basically everything that we normally would call works, will be done with the help of AI. And so the big question is, should that ultimately be copyright protected or not? So I think the only thing that I believe at this point is clear, the more sophisticated the prompting is, the more individual elements you include, that you would say maybe not one single item of that, but the bulk or the overall, the sum of these contributions make it more than just an idea, more than just a guideline, make it a reflection of someone's personality, and those should be copyright protected.
Yeah, because examples I've seen in architecture, for example, the prompts, they can be 2 or 3, even 5 pages long. So clearly it includes some kind of human creativity of guiding the AI to do something. But we have a little time, and we have the final slide. Next slide. Yeah. Yeah. As for damages caused by AI, maybe a hot topic, but in the end, if they consider damages caused to third party, well, even today, people use various machines to do something and usage of these machines, like cars or construction equipment or whatever, it may cause damages to third parties. And therefore, the thought acts as they are, the damages. I think we fully agree that they should be as they are. AI, in a sense of thought legislation or damages, they are just one kind of machines, which, well, may cause damages.
I think the big thing here is the gap between responsibility and accountability. So, self-driving car was responsible for that accident, but who is accountable, legally liable for that? So I think that's something, but I think that also can be solved quite easily.
With existing laws, because it's a human who makes decision to use AI for certain activity. And then whether that human acted negligently or prudently when he decided to use AI for that activity, it's one thing.
You devoted one chapter to contractual liability in your book.
Yeah, because contractual liability, it's fairly easy. Giving access to AI, typically the provider of AI system simply limits his liability to almost nothing. Just like software, there's nothing new in that. And of course, the contract is the law between the parties. But criminal issues, that's something that is often overlooked. Criminal issues, they are people forget easily that the AI can be used for criminal activities, and that is actually something the governmental officials are extremely interested in, because it will be used for fraud, it will be used to design far more advanced money laundering schemes than currently exist. It will be used for harassment, and it will be used for deep fakes to be utilized in frauds or just harassing someone.
Do you think the law is prepared?
Yes, because if they consider this criminal element of AI systems, let's say that you want to murder someone, and that someone you want to kill drives a car with autonomous steering system, like Tesla Autopilot and many others like that. In University of Berkeley and others, they hacked these systems. What they did was to put the pieces of tape about size of matchbox in pre-designed pattern, and they.
It's to go for less than 5 minutes.
Yeah. So they messed this. My watch says 1 minute. They messed them up, and the systems. They thought that the stop sign was a speed limit for 70 kilometers per hour, wherefore the autonomic driving system drove the car through crossroads at that speed. And if you kill someone like that, well, you can shoot someone, you can poison someone, you can strangle someone or stab someone, or you can mess up with such steering systems. In sense of criminal law, it doesn't matter.
So when we look at all these things that we basically try to discuss, and the discussion could go forever, I think for me, one thing is I think we have to apply expectation management. So we call it artificial intelligence, but actually a much better expression would be, or term would be, cognitive machines, because it's more sober, more realistic. Because as Dai rightfully said, intelligent, why is it intelligent or artificial and all that? So it creates a lot of expectations, and I think for nothing, because a machine code it's just different. A human being is still in many ways superior to a machine. So if you train a cognitive engine or an AI system, and you try to teach the machine, let's say in a war situation, there is an attack by soldiers, and each of them has a white flag. So the machine thinks, oh, this is basically peace. It means peace because I see so many white flags. A 5-year-old kid would easily understand the trick. So they're a soldier, they're using something just to tramp me. But this is an attack situation. You can train the machine to understand that, but you will use millions of data sets to train the machine from scratch, because it doesn't have the same type of learning that we have. It needs a lot of data and abstraction and all these things that I think are contributable to a human brain do not exist within a machine. However, the scientists are getting closer, so they're using neurology, and they will try to imitate the human brain as much as possible.
Very well, thank you.